A very warm welcome in the second module of week 8 of the course Roadmap for Patent Creation, titled Post Patent Filing Mandatory Requirements, Statutory and General. There are two important mandatory requirements. Let us check which are these requirements. The first one is statement and undertaking under section 8 form 3. Let us check what is that form 3 is. This is the declaration. So, it is a declaration as it says that I or we, if applicant is that if a number is more than 1, you will say obviously we, hereby declare that we have not made any application for the same or substantially the same invention outside India. The meaning is that when we say same or substantially the same invention outside India, this is the declaration you are giving at the filing of the patent. So, when you are filing the complete specification, you will say that you have not made any application other or outside India. But now suppose you enter into PCT phase after filing the patent application, maybe provisional, maybe complete, whatever the stage might be, and then what you will say, you have to give the declaration. There is a timeline of 6 months after any filing in any other country. If you do, within 6 months you have to inform India Patent Office. So, at that time you have to give this form 3 again, right, and what you will say at that time, you will say that okay, that we have made this application number, and you have to give the number. If suppose you have filed it in USA, you have to give that number, the date, and then you can say that alone or jointly with, if you have added, because remember that you can add as a applicant, you can change inventor after filing a patent, that provision is there. So, if you have done that any changes, you can just inform to the patent office, and then you say that okay, same or substantially same invention or application for patent in the number of in that other country, and then you will give the particulars of that particular application. Now, in the particulars, what exactly you will give? You will give the name of country, then you will give the date of application, then you will obviously share the application number. You will also have to share the status of application, then you have to share date of publication and then date of grant. So, if that information is there, date of grant, date of publication, obviously you have to share that information through this form 3. This is a mandatory requirement. So, here what you are doing is like a section 8, that section 8(1), when it is read or when it is considered with the rule 12 of India Patents Act, right, and there is also rule 5. If we see this sections, that is section 8, rule 12 and rule 5, it says that the applicant is expected to furnish the information of every other application, if any, filed elsewhere subsequent to the filing within 6 months of filing of such new application. So, whenever you will enter into PCT application, or you are giving a PCT, suppose you opt that PCT route, when you enter into that national phase after maybe 18 months after publication, that 19th month, if you may go into the national phase, that is after that 19th months, or if you do that national phase entry after 30 months, then at that time, whenever you will enter into that national phase, and if you file in say 6 countries that application in that 6 countries, then you have to give this form 3. You will give the all details of that 6 filing, and then you will submit that form into the patent office, and this is a mandatory requirement. This is like you are informing patent office that this patent application, it is under consideration here in India Patent Office. It is also applied in these 6 other countries. So, that information you are providing. So, this is the first mandatory requirement if you are filing patent outside India, right. Now, let us check the second mandatory requirement. What is that second mandatory requirement is? Now, this is relating to the working of a patent, it's fine. So, it is a statement regarding the working of a patented invention or a commercial scale in India. Now, this is dealt by section 146 of the Indian Patent Act. Now we know that this is like a, this patent is like a, what you can say, this is a expected that your patent you should commercialize it. So when you are doing the commercialization of that patent, you have to inform whether you do commercialization or you do not, you are not doing the that commercialization. If you are doing commercialization, obviously you have to give details regarding that thing. If that commercialization is not started, you have to give the reason why that commercialization is not there. This is a mandatory requirement for Form 27. If it is a mandatory requirement, patent office has started sending you mail, or patent office will so actively communicating with the applicant, and it is expecting that what is the status of your patent. You have applied, it is now what is the what in what stage your patent is, whether it is commercialized or early preparation is going on before commercialization, whatever that thing is there, that you have to share. Now how will you share that thing? Form 27 is there. So what information you have to give in Form 27? Whether the patented invention has been worked or not. So that is the first. If not worked, the reasons for not working that particular patent, why it is not worked, that information you have to give. If it is worked, then quantum of that value. So you have to give the, you have to disclose that in rupees, whatever that value is, and how much, what we can say, the business is done by that particular, because of that particular commercialization activity. The commercialization activity can be, you have manufactured it in India. The second probability is that you will manufacture particular thing outside India, but you have imported it in the country. This may be the possibility. The other possibility is that you might have done licenses or sub-licenses. So you can give information about that licensing and sub-licensing, if any, and you can give the, maybe that information, whatever is there, that details you have to share. Then if that particular, whether this public requirement has been made by that particular patent. So for example, if your patent is related to drug, whether that drug requirement, if it is there in the country, that complete requirement is fulfilled or not, whether the price which is what we can say for that particular drug, whatever price is decided by the applicant, whether it is a reasonable price or it is not reasonable, right, or it is a very, what we can say, exorbitant price, what that condition is, that also you have to, that also is a very important point which is considered. Now why that is important, and if that exorbitant amount or it charge for that particular product or particular drug, what can happen? Because if that kind of thing is there, that reasonable requirement, a reasonable pricing is not there and requirement is not fulfilled, it is like something you have offered monopoly by the state, but you are not completely exploring that right, and although there is a requirement, you are not providing that product to the public who are in need of that particular product or drug or whatever it may be. What is the remedy for that? In such a cases, section 84 is there, that is a compulsory licensing is there, and anybody who is interested to do the production of that particular drug or product, they can approach patent office based on this point, that is a pricing is not reasonable or the sufficient supply is not there. Based on this, what we can say, 2 points, anybody can apply for a that rights for that particular production, and they can claim that okay, we will provide this product with this rate and kindly grant us the kindly give us the opportunity to do that thing. So patent office can consider that thing. So we can just check this example. Now here what we can say, the patent office found that where the company that did not imported the drug at all, they got the patent, but they have not done the import of that patent in 2008. That importing they have started in small quantities in 2009 and 10. Now seeing this activity that Bayer was not making the drug accessible to more people, NATCO applied for a compulsory license under the section 84 of India Patents Act, which was then granted by controller and then upheld by the Bombay High Court. But such kind of cases you will observe, and the information about that working of patent you have to give, it is a mandatory requirement and you have to give it yearly before March ending. So that requirement every applicant has to provide to the patent office. Now So, these are the two, what we can say, the compulsory requirement, mandatory requirements are there, form 3 and form this 27, that is a important mandatory requirement. Now, before entering into that general information or what are the general requirements after patent filing, a few important things I wish to put forward. There is form 5 available. We know that there are 30 forms are there. Why I am mentioning form 5? It is related to inventor addition. Now, what is that? Suppose you have filed a patent, and when you are filing a patent, 3 inventors are, that names are there, and later something is arised and you realize, oh, this name is missed or whatever the reason might be, and you want to add the name of the 4th inventor. Then you can use this form 5 duly signed by applicant, and then with this form you can do the addition of inventor. So, that addition you can do. If you want to change some name of the applicant, that form 6 is available. When possibly that applicant name change, if you are selling that patent, if you are assigning the rights to other what we can say applicant, obviously at that time you are changing the applicant, and then form 6 will help you to change the that applicant name. Then if any other amendments are to be done into the patent, form 13 is available. So, be not under the impression that once patent is filed, it is a full final thing is there. There are provisions, if you want to make these kind of changes, the forms are available and you can make such changes. Okay, so, this is a little bit added information I wish to share. So, form 5, form 6 and form 30. Now, we will see the general requirements. Now, probably by after going through this so many lectures, almost 35 plus lectures you have gone through, that videos you have gone through. So, you have understood now what are the general requirements after complete specification filing. Okay. So, but sometimes what happens, due to that unawareness or that ignorance or that what we can say, if you have not kept the track of that application, you may miss the procedures, and that are the important procedures. If you miss the opportunity of your getting grant of the patent also. So, which are these general requirements? So, you know that request for examination, mandatory thing is there, and we have already shared with you that it is always suggested that you should file form 18, request for examination, when you are filing a complete specification only, and we have given the reason also why. Means if you want early examination of your patent, because your what we can say, the number in that particular queue is determined by this request for examination. So, you have to give that along with complete specification, but due to some reasons, if you decide that okay, we will file that request for examination later, then you have to remember that you have only 48 months. If you miss that or cross that 48 months timeline, you are losing your patent. So, that is the what we can say the important. Obviously, it is a statutory requirement, but we have just we are now after going through this 35 videos, we consider that you are aware about this thing and you will take care of that thing. Then the after provisional or complete, whatever the patent filing you are doing, obviously you have to remember 12 months timeline for PCT or conventional patent filing. If you miss that timeline, you are losing the losing your rights in other countries. So, PCT or conventional 12 months timeline is important. The next thing is that FER is very important, means it is not the case that you have filed patent, you have given the request for examination and automatically it will be granted. That is not the case. So, whenever examiner will do the examination and he will generate that first examination report, that FER will be communicated, means that you will, whenever you will receive that thing within 6 months, you have to give reply to that FER. That is again the important task you have to do. If you will miss that 6 months timeline, again you are losing your patent. Next thing is, if hearing is scheduled, then you have to remember that you have to take care of that hearing, right. So, if it is scheduled, that hearing is scheduled, you have to make sure that you are attending hearing. Obviously, we have already shared with you that for hearing you need not to go to patent office, by video conferencing you can attend that hearing. Then unfortunately, if any opposition is there, then again the timeline is important. If any opposition related document is communicated to you, then you have to give reply to patent office with the evidences. That is again the most important thing. So, although it is general, but again this is something which is a mandatory things obviously, and you have to follow when you are doing after that filing a patent. You have to follow the what we can say all these requirements are there, and you have to follow all these things. Next thing is a commercialization. Form 27 is expecting that you have to do the commercialization of your patent. It is not a research publication, it is a patent. Patent is for wealth creation, and so it is expected that you will do the commercialization of your patent. Now, here the important thing is that obviously we have that one dedicated lecture on commercialization, and you know that that you will see that which are the different ways for the commercialization. And as already many times we have seen that this innovation process, then IP management process and commercialization process, all these processes should go simultaneously. You can't wait till the grant of a patent and then you will think of a patent commercialization. This is not the case. Okay. So, once you do this commercialization thing, obviously it may be a joint venture, it may be a startup, it may be a licensing, it may be collaborative activity, whatever it may be. After that, that whatever the procedure means, we can say that you will start the revenue generation from that patent, and obviously you have to do the that information means through the form 27 you are continuously informing patent office about the working. The next important thing is a maintenance fee. So, you have to remember that for a patent after grant you have to give maintenance fee till the end of a what we can say total that 20 years is the life of a patent, and if you want to keep your patent live, then you have to give that patent maintenance fee. So, you will not miss timelines for giving that maintenance fees. So, form 27 and then the that maintenance fees, again the important thing is that if you miss giving that giving that maintenance fee, again you may your patent after that grace period is there, but after that grace period your patent will enter into the public domain. So, you have to take care that you will give that maintenance fee timely, and you have to complete these requirements, that is form 3, form 27, all this what we can say the general requirements like a request for examination or the PCT conventional if you are interested, FER reply mandatory, hearing mandatory, if opposition reply for that opposition mandatory. Commercialization, I will say it is also mandatory, no, although it is general, but it is mandatory because you have to give that form 27. Maintenance fee, that is again the mandatory thing if you want to keep your patent live. Okay, so these are in short what we can say the post filing requirements for the patent. Now, let us watch one interesting video here.
Hi, I'm John Risby, the patent professor. A utility patent application defines the nature and use of a new product or process and its applications. One of the most common questions I get when a non-provisional utility patent is filed is what happens next? Well, once the patent application is filed, the process is just getting started. The patent office has to review the patent documents and determine whether the invention is patentable. Because the patent office has a lot of filings to review, this takes time. Sometimes the patent office will just accept the application and move on, but this is rare. Often, the patent office will decide that the application is too similar to or not unique enough from other existing patents or filings. Many inexperienced inventors make the mistake of thinking this is the end of the road and their patent application is rejected. In reality, this is an invitation from the patent office to explain to the examiner how the invention varies from the other patents that the examiner has found. The patent office may misunderstand the filing or think that your invention is too similar to something else that has been filed in the past. Sometimes this can be corrected by filing an amendment document that demonstrates why the patent is different. The patent office may accept or reject the argument or request further clarification. If the patent application is accepted at any point, it moves to being issued and printed by the patent office. If it is not, then the process is repeated. The key here is to find the right mix of phrasing and language to showcase the uniqueness of your patent and why it is actually patentable. The goal here is not to give up. I've helped a lot of inventors get through the confusing and sometimes frustrating patent process. A statement from the Patent Office that your invention is not patentable does not mean you don't have a viable invention. Work with me, the patent professor, to make sure you don't lose your patent.
Okay, with this we come to the end of this session on movements, and we will see the next session, that is on the most important topic, that is a patent commercialization. See you in the next session. Thank you.